Hello, good morning.
Good morning.
Good morning, everybody. Let's welcome to our webinar unofficially, but let's wait another 30 seconds because I see that some people are still connecting. We'll start in 30, 25 seconds. Okay, I can see that I think we have everybody. It's 5:11. So let's start. So once again, good morning, everybody. Welcome to this webinar from Filip Kowalczyk and myself. My name is Grzegorz Wozniak. We are both representing Wozniak Legal, and I'm very happy to announce that this is the first webinar which we are presenting in 2026, and I'm very happy to tell you that this is really the topic of today's webinar is one of the hottest topics on the Polish business market at the moment, which is the new proposed new draft law on new competences of the state labor inspectorate, which was supposed to grant inspectors special extraordinary powers to reclassify civil law contracts into employment contracts. I will just give you some practical information first about our webinar. We intend to go on for approximately 45 minutes to roughly 1 hour. It is possible to send us questions during the webinar by clicking the question mark button. And at the end of the webinar, during the Q&A session, we'll try to answer. I cannot promise that we'll answer every single question, but we'll try to answer some of these questions. And we are very happy. We encourage you to ask these questions. No other participants. This is important. Sometimes you are afraid to ask questions because other people will see it. No other participants will see the questions, so feel free to ask these questions, and as I said, I will try to answer at the end of the webinar. If you have questions which cannot be asked for any reason during the webinar, please send us questions by email. Our details will be later presented, and telephone number, so we'll be happy to help you, and you can contact us by email or by telephone. We'll be happy to help. Before we start talking about the main topic of today, so the new proposed law on state labor inspection, let me tell you briefly about our company. So we were established. Wozniak Legal is one of the best Polish law firms, commercial Polish law firms. We were established in 2007. Our main office is in Warsaw, although we work with local lawyers throughout the country. We have about 15 fee earners at the moment. We work closely with, this is important maybe in the context of our webinar, we work closely with auditors and forensics and accountants, and from time to time, not on a regular basis, but we've been involved in social security audits or state inspection audits. So then, if such a case happens, we cooperate closely with other professionals on the market. So we have a broad experience, not only on the legal market, but on a business market. The agenda for today is briefly we'll give you some really basic information about the topic, which was supposed to be more focused on the changes, but because in the last moment the proposed law was postponed for further revisions, we'll focus more on the current status and not on the future changes. So we'll just give you some presentation about the labor law in Poland in general, and then the main topic of today's webinar will be really comparison between the traditional employment agreement model and the so-called B2B agreement model, and how what are the differences and what is the using of the first model versus the second model. Also, we will, as you see in point in point 4, specific work, especially in IT industry in Poland. It is very popular model of employing people. This is a contract for specific work. So we will also in point 4 cover the contract for specific work, which is in Polish umowa o dzieło. And then we'll present the case study and Q&A session. So let's start from point number 1 on our agenda is introduction to labor law in Poland. Let me tell you in general that Poland still is one of the most attractive business locations in Poland, and the reason for this is central location, attractive labor market, and facilities for foreign investors. These are just some of the benefits of starting a business in Poland. And then when you start a business, one of the first questions is, how can I hire people in Poland? So basically, we have under Polish law three ways of engaging individuals. Employment agreement, which is governed by provisions of the labor code. We have the civil law contract, which is, as I mentioned, this contract for specific work, which is a contract which is not governed by the labor provisions, which is absolutely outside any sphere of regulating the employment relationship by the labor law. And we have Polish phenomenon, which is a B2B service agreement between two entrepreneurs, which is a contract between the employer on one side and then the contractor, as you can call it. There are various ways to describe this person in English. It's self-employed or contractor, which normally has to also be registered as an economic entity. So we have agreement between two entrepreneurs. And then briefly, let me give you update about the current situation and why did I say so boldly that this is really one of the hottest topics on the Polish market at the moment. And if you happen to be in Poland, you can hear and see the discussions about this law on every TV channel, on every radio station, on social medias. There's a discussion about the new law because this proposal sparked intense controversy and discussions about the proposed changes, which is the workers' protection on one side and business flexibility on the other side, and really the opinions are divided. But the background to this is that last year the Polish government prepared an amendment to the Act on State Labor Inspectorate, and these amendments were supposed to grant really extraordinary powers to State Labor Inspectorate, powers which were supposed to grant them even authority to issue decision to reclassify civil law contract into employment agreements. And the plan was, and this was the plan of our webinar also, to present you really the law which is coming into force, maybe not on the 1st of January, but on the plan was, as we say here, that this new law will come into force on the 1st of May or 1st of June. But suddenly, just at the end of the last year, the government, after debate, discussions, and as I said, the proposal sparked this intense controversy, and not only in the society, but also within the government, which is coalition government. And they decided to really send the draft for further revisions. The draft provided for significant strengthening of the powers of state. As I said, the main objective was to ensure more effective action against so-called fictitious self-employment. Because self-employment is legal, is acceptable, but it cannot be fictitious self-employment. Fictitious self-employment is when actually the employee is under the employment agreement, but the parties call it for various reasons self-employment. We will come back to this because we will have to probably somehow refer to the proposed changes anyway. But let's go on with our presentation. Classification, employee or contractor.
The distinction between employees and contractors, often referred to as self-employed individuals, freelancers, or B2B service providers, this is a fundamental issue in employment and in commercial practice. This proper classification is crucial not only for determining the applicable tax and social security obligations, but also for identifying the scope of statutory rights, benefits, legal protection, and regulatory compliance. And misclassification may result in significant legal and financial consequences, including liability for unpaid taxes and social security contributions, also administrative penalties and claims for employee benefits retroactively. For this reason, the assessment whether an individual should be treated as an employee or as an independent contractor must be based on the actual nature of the relationships rather than solely on the title or wording of the contract. A similar distinction applies to individuals engaged under a contract for specific work. In Polish, it's called umowa o dzieło. Unlike employment relationships, a contract for specific work is focused on the delivery of a defined and measurable result rather than performance of work under the direction and supervision of another party. As such, it does not create an employment relationships and generally entails different tax and social security implications, as well as significantly narrower scope of legal protection. In practice, the classification depends on a number of factors, including the degree of control and subordination, the level of independence in organizing the work, the allocation of economic risk, and whether the individual is integrated into the organization of engaging entity. Where the factual circumstances resemble those of employment relationships, the arrangement, the contract may be reclassified as employment, regardless of the contractual label chosen by the parties.
If I can just add one point, if we can maybe go back one slide to presentation of this, just to give you full picture, and then why this distinction, which my colleague discussed now, between employee and contractor is so important and so vital, is that when you look at these three ways of engaging individuals, there is a huge difference in costs for the employer, for the company, because under the first bullet point, employment regulation, the employer pays not only salary but also pays social insurance premium, pays income tax on behalf of the employee. So these out of these three models, the first is really more costly for the employer, and this is why in practice the other two solutions have been developed, and the importance is so big now on the market, especially in some sectors like IT industry or anywhere where you can hire freelancers, because civil law contract and B2B service agreement, The main difference between the first one, employment agreement, and these two is that the company does not pay any extra costs. So if we have a look at the civil law contract, the company pays only agreed remuneration for the work which is going to be created, and no further expenses, no further benefits are being provided by the company. That's why this solution is very often preferable by freelancers, because they, of course, as a result of this, that the company does not pay any extra charges, is that the company may pay more money to the contractor. And the same happens with the third contract, B2B service agreement. Again, the company, so the employer, does not pay any further costs. Everything is being paid. The company just receives an invoice from the self-employed and pays invoice, usually with a VAT, which is neutral because it can be offset. So that's why the distinction whether it's an employee or a contractor is so vital, because it's not only terminology and whether you feel better being called employee or contractor, but in terms of money, this is a huge difference for the company whether individual can be called an employee or a contractor.
So there are 4 key considerations. The first one is subordination. So a defining feature of an employment relationship is the existence of subordination. Employees perform their work under the direction and supervision of the employer, who determines how, when, and where the work is carried out. The employer may issue binding instructions, set working hours, designate the workplace, and integrate the employee into the organizational structure of the business. By contrast, contractors operate with significantly higher degree of independence. They are generally free to choose their own methods of performing the work, organize their time autonomously, and are not subject to ongoing managerial control. The second one is the remuneration. So employees are entitled to statutory remuneration protections, including the guaranteed minimum wage, and in many cases, additional compensation for overtime or night work. Remuneration is typically paid on a regular basis, regardless of the immediate results achieved. Contractors, on the other hand, are not covered by minimum wage regulations in the same manner. Their compensation is usually free negotiated and defined by contract, often based on hourly rates, project milestones, or completion of a specific task or result. The third one is social security and benefits. So employers are legally obliged to register employees with social insurance institution, it's ZUS in Polish, Zakład Ubezpieczeń Społecznych, and to pay mandatory social security contributions covering, among other things, pension, disability, healthcare, and accident insurance. Employees are also entitled to a broad range of statutory benefits, including paid annual leave, sick leave, and additional remuneration for overtime and night work. So, on the other hand, contractors are generally responsible for arranging and financing their own social security coverage and benefits. Depending on the type of a civil law contract and the individual status, contribution obligations may be limited or structured differently, and statutory employee benefits do not apply. And the last one is risk and liability. So in employment relationships, the employer bears the economic and organizational risk associated with the performance of work and is responsible for ensuring safe working conditions. And employee liability for damage caused in the course of employment is typically limited by law. And contractors, by contrast, usually bear their own business risk and are liable for the proper performance of their obligations, including the quality and timeliness of the work delivered. In particular, under contracts for specific work, liability is closely linked to the achievement of the agreed result. So, dzieło in Polish.
Correct, yeah. Now the B2B, as we mentioned earlier, B2B services agreement or service contract. As I mentioned earlier, we have the three models: employment, civil law contract, and B2B. B2B contract developed to a into a very popular, especially among the programmers. And some people refer to this. I mentioned earlier this intense controversy on the proposal of the new law sparked such intense controversy because it is really controversial. Because some people refer to the contract which my colleague described in a moment, this contract for specific work, and B2B contract as a junk contracts, umowy śmieciowe, or gig economy in English. So contracts which do not give any. It's a short-term contract which do not give any protection to the workers, to the employees, and generally contract which should be really eliminated from the legal market, from the market. But this is not really the truth because it really depends on the industry. In some industries, this is not that people are being pushed out to the B2B model or specific work contract model. It's simply it is being agreed by the parties that will be more beneficial for both employer and employee that they cooperate under the different structure than employment agreement. So sometimes we have a case. That's why maybe this controversy is so fierce and so intense, and it's really not decided what option is better, because in some sectors the using of B2B contract or specific work contract is absolutely legal and acceptable, and in our view, the market should keep it because it gives our labor market more flexibility. As I said, Poland attracts investment, and the three pillars of this attraction is central location, attractive labor market, and when we talk about attractive labor market, is one of these features is this flexibility that you can really find a proper solution how you want to employ people. B2B contract in Polish environment means that the employee or the Polish individual who wants to sign the B2B contract needs to set up his own business, which is easy because he just needs to register himself as a business with the local municipality office, and then he invoices the company for his services. The administrative burden for the company is much lighter, but as we say here on this slide, this arrangement is suitable only if this relation is genuinely business to business and not as an employment relationship. So what happens very often on the Polish market, that this model is being misused, that sometimes the companies push out people in various, and this is not the sector of IT, but there could be industries where people are against their wills are pushed out for the B2B model, and this is not good. And if the self-employment is fictitious, which happens sometimes, and the actual conditions meet the criteria for employment relationship, the contract may be reclassified as an employment agreement. And this is key of the problem. I think this is where we really can talk about this new law, because the new law, this proposal, was supposed to grant this extraordinary powers to state labor inspectorate to, if the contract may, if the actual conditions meet the criteria for employment relationship, the contract may be reclassified as an employment agreement, and this could be done under the new law if the reform is passed by the inspectors. So they do the audit, they verify everything, and actually one of the elements of the new draft law is that the audit can even be done remotely, so they don't have to come to your office. They can simply connect you online and review the documents and make verification whether the self-employment in your company is fictitious or not. And if it's fictitious, in their opinion, they can issue decision that this should be classified as an employment agreement. So, and the aim of our webinar was what to do, how to avoid this risk. So the title of our webinar was how to avoid B2B versus B2V versus. Let me refer to our web to the B2B or employment, how to avoid reclassification risks. So when we talk about, and just maybe a short introduction, even without this law, which is being now being postponed, and we don't know when what will happen with this proposal. It's important for you to know and to understand that the law simply grants new power, extraordinary powers to inspectors, but doesn't change anything in the law. So when we talk about the contract for specific work or B2B or employment, the law is as it is, and these distinctions are quite visible, are quite distinct, and the best formula is really trying to avoid the risk, because even if the new law is not passed, there are other inspections and audits which could happen. For instance, the social insurance inspections happen from time to time, and they can verify contracts which is being used, and they normally take at random several contracts, and they try to verify whether it's a fictitious civil law contract or employment, and they can issue. The only difference now with the current status is that they cannot issue any extraordinary decision about reclassification. They have to just write they have to report irregularities, and the court actually has to issue a decision on reclassification. So coming back to our topic of this webinar, how to avoid reclassification risk. To minimize reclassification risk, the B2B model must actually differ from employment in how cooperation is organized, not just the wording. So it's not enough just to modify the wording so it looks perfect. So we say in the agreement that the contractor is fully independent, and the parties mutually agree that this is a B2B relationship and there is no supervision. And actually what happens is that must be really, organization of this cooperation must be done in such a way, because in audit inspection looks at how it is being organized. And I think it has to be reminded again and again that under Polish law, the employment relationship exists when the work is performed personally under employer's direction and at the place and time set up by the employer. So and it doesn't have to be any concrete result of this cooperation. So the more we go from these 3-4 elements of the employment relationship, the safer we are with B2B model. To avoid reclassification, B2B setup should clearly eliminate typical employment elements in practice. Of course, it's not possible to eliminate personal performance of the contract, because we still talk about hiring and engaging a person. But all other elements should be eliminated as much as possible. And the biggest problem in practice is how to prove or how to show to the inspector, to the inspection, that the contractor is really independent. Because if he is being paid under the B2B contract, the default position is that, okay, so we give him instruction, we supervise his work, we accept his work or his services, so he is dependent. Proof of contractors' independence are very important, and from our practice, we come from we verify various solutions like separate website for a contractor or business card of a contractor. But the best model or the best solution always is the multiple clients. So how to distinguish employee from a contractor? Contractor usually has more than one client. So to minimize reclassification risk in this B2B model, the contractor should have more than one client. Then he can argue that instead of having my main recipient of services, which is the company, I also have other clients.
So another solution is a contract for specific work. As I said, umowa o dzieło in Polish, sometimes referred to as a project-based or result-oriented contract. This type of agreement may offer several compelling advantages, particularly for IT specialists or programmers and other highly skilled specialists, making it an attractive and, in certain circumstances, an optimal alternative to traditional permanent employment. So a contract for specific work is governed by Polish Civil Code, not Labor Code, and is centered on the achievement of a clearly defined individual result. So in a context of software development, such a result may include the delivery of a specific application, program, module, functionality, or other identifiable and verifiable output. The contractor's obligation is not to perform work under supervision, as I said, but to deliver the agreed outcome in accordance with some specifications which are set out in the contract. From the practical perspective, this model allows a high degree of flexibility and autonomy, and the contractor typically retains discretion as to how the work is performed, is not subject to fixed working hours, and it's not integrated into the organizational structure of the entity. So this independence is a key factor distinguishing the contract for specific work from the employment contract. It should be noted, however, that the use of contract for specific work requires careful drafting and factual alignment. When the relationship in practice resembles an employment relationship, so particularly when there is ongoing supervision, fixed working hours, or continuous performance of tasks, there is a risk that the arrangement may be reclassified by the court, of course, with associated legal and financial consequences. To minimize the risk of reclassification, a contract for specific work must differ from an employment relationships not only in name, but in the actual organization of cooperation. Merely adopting contractual language typical of civil law agreements is insufficient if in practice the relationship mirrors the characteristics of employment. equally important, the contract must lead to the creation of clearly identifiable and individual work, dzieło in Polish, that can be objectively verified and accepted. Under Polish law, the employment relationship arises where work is performed personally under the direction and supervision at the place and time designated by the employer for remuneration. And these elements, assessed cumulatively, form the legal test for the existence of an employment relationship, regardless of the contractual label chosen by the parties. So to avoid the reclassification, a specific work arrangement should clearly and demonstrably deviate from these elements in practice. So in particular, the contractor should retain autonomy in determining how the work is performed, should not be subject to day-to-day managerial control, and should not be required to adhere to fixed working hours or a designated workplace. The focus of the relationship should remain on the delivery of the agreed result. And the contractor should also bear the responsibility for the proper execution of the work and, where appropriate, the risk associated with its delivery. So the proper documentation, including precise specifications of the work and acceptance criteria, plays a key role in supporting the civil law nature of the arrangement. So, in summary, a contract for specific work can be a lawful and effective model of cooperation, provided that both the contractual framework and the factual execution of the relationships consistently reflect its result-oriented and independent character, clearly distinguishing it from employment.
Correct. Yeah. So we just heard that the elements which can create problem in when we talk about specific work agreement is subordination, regularity, and the place of performance, which is the company's place. So we have to minimize the risk of reclassification or negative results of the audit. It's important to avoid the three things: subordination, regularity, and place of performance in the company. So the contractor should not be subordinate in performing his work. It should not be too much regularity. I will talk about this in a moment. And the best solution is that he is not performing his task in the company's offices, but rather at his own place. When we talk about this comparison between specific work or contract for specific work and versus employment, it is also important that even in the name contract for specific work, we talk about specific results. So there has to be a specific result which is measurable, and normally it's not only specific results. Specific result just to give you more information, there should be work under the Polish law on copyright. So there has to be something which can be measured, tangible, like writing a poem, writing a novel, creating a software. Yes, something which because the whole thing, if there is no work, so there's no specific result which can be measured, and then of course it could be debated whether it's a really tangible work or not. But if we apply this model to into a situation where there's no work, there's no specific result, then the whole thing collapses. And obviously this is the main argument to say that this contract is fictitious, and actually it's an employment agreement. So copyright, and very often if we have the creating of the IT or creating the software, very often the copyright is involved in this. So usually contract for specific work includes the transfer of copyrights to the company and is beneficial to the IT professionals in Poland because it allows them to apply the favorable tax regime and pay less taxes. So this is an additional advantage for them to use this structure. And as I said at the beginning, that very often people refer to these two forms of employment of engaging people, so civil law contracts and B2B contracts as gig economy, so something which should be eliminated and should not exist. But very often it is really agreement between two parties. So we have a contractor who is creating, and if he or she is creating really a software and there are copyrights attached to this, because every creator under Polish law has copyrights which can be transferred to the employer. So it's very often that the parties agree between themselves that this really should be a specific work agreement and they want to cooperate on this. So they are not being pushed out. But as I said, also there are examples, negative examples that being forceful are being pushed out to civil law contract without protection. If we can maybe come back to one of the slides earlier when we talk about the new law, introduction to Polish. So I would like to just say that there is even without the new law, there are still at least several. I would say 3 inspections which are really threatening the on the market if you use the fictitious. So the bottom line would be that it would be best not to use the fictitious contract, because it really should be if you employ, you have a choice as a being company, being employee, you have a choice between three models. Employment agreement is the best as the most recommended model because it gives full protection to the employees. It also covers the copyright issues. So if you have a programmer, and I refer very often to programmer, to IT industry, because that's where we have more experience in this field, and really these models are being used by IT industry in Poland. So the first one, employment agreement, is the best solution. It's costly, but it's really, I would say, middle of the road. So it gives protection to the employees. It gives them benefits. It gives them things like holidays, sick leave, overtime, and full protection. Yes. So and then these 2 other solutions, civil law contract and B2B contracts, do not give them. And very often and very important, employment agreement also covers the copyrights, while the 2 other bullets, civil law contract and B2B, civil law contracts are fully dependent on this specific, as my colleague mentioned, on this specific result. So there has to be a work created, a work which can be tangible, measured, and verified, especially in the case of an inspection. So the first question when they start reviewing the contract is, okay, has there been any work created under the contract for specific work? Where is this specific work? And if the company is not able to present the work, then of course there's no need even to carry out any further verification, because if there's no work, the contract is fictitious. And B2B is not so strict, because under the B2B agreement there does not have to be any specific result and a specific way. It's simply services, but the problem is that it has to be real independence, which should be presented, which is not so easy. Even if it exists in practice, this independence, it has to be somehow manifested and shown to the inspectors during the audit. When we look at the three forms, it has to be really used wisely. Yes, the number one, employment agreement, can be used always and is the best. The two other, it could be somehow, it cannot be overused or misused. It has to be used, but with a wise approach, with a very clever verification of the situation, and of course in cooperation with the contractor. So yes, so that's our. As I said, we just touch upon these topics without going into, because it's a very broad, very deep subject, and we just wanted to give you highlights of what is going on, and our plan was that if the new law would be passed this month in January, then probably it would come into force on the 1st of May. There would be really a very short time to prepare for the new reality and start changing and start improving and start eliminating these points of the setup which can cause risk of reclassification. Now we can say that you have more time, really, because we don't know when the new law will be passed. There are various voices. Every day we have new information, and I think we'll start with this case study, which should be very interesting, and will show you all these problems in a nutshell. But just that, let me finish about the plans about this new law. It is not so easy, because now if the government wants, because the new law, this proposal has been agreed already, not only within the government, but also has been agreed with the European Union as part of our recovery plan, as a milestone in the recovery plan. So now, if the government now decides to change in significant parts of this proposal, they will have to renegotiate it with the European Commission, which is not easy. So it could be that it will be another year, because these negotiations are not easy and have to be approved by the Commission. So the realistic approach is that it will not happen this year. Maybe at the end of this year. So probably it will start in 2027, or maybe there will be the law will not be adopted at all, and the government will try to somehow amend other laws, or will add some provisions of law which allow for the increased control being exercised by this controlling bodies, and we have at least 3 controlling organizations in Poland, because the first important is the State Labor Inspectorate, and they were supposed to be given this extraordinary powers, but they still have, even with today's law, they can, and they do carry out audits. So they can come to your company, they can verify the contract, and they can give you instruction on negative conclusions, and they can try to force you to change your ways. So I said 3 institutions. We have State Labor Inspectorate, we have Social Insurance Audit, so ZUS audit, which is also not a piece. It's not a piece of cake, because they can come to your office, and they cannot verify the B2B agreements, because this is outside their scope, but they can verify all agreements which should be covered by the social insurance payments. So this is it could be dangerous if you have a company and you employ people under the civil law contract on a fictitious civil law contract, and you have a ZUS audit. You are very likely to have problems, and without having authority to reclassify your contract, they can still report irregularities and they can force you to change your contract. And the third controlling authority is, of course, tax authority, because they can verify your agreement, they can check your contracts. So these three institutions can verify correctness of your agreement. So I think it's really beginning of this year. It's still, I think, the signal from our side, and as you can see in our case study, should be that there is no time to lose. All the irregularities existing in the company should be clarified and changed into a model which is absolutely legal, acceptable, and cannot risk reclassification. Case study, I'm conscious about the time passing, but quickly, the case study, which is the background is not too difficult. It's and it's taken from my practice. We have a US corporation which operates in Poland, in euro through Polish subsidiary, and the Polish company employs IT developers, programmers in Poland, and this is very common example that they use all possible scenarios. So there are employment agreements, there are contractors, there are contract for specific work, there are B2B agreements. And I can tell you from my practice that really programmers in Poland love their contract for specific work because it gives them flexibility, it gives them really independence, and they can earn more. So it's very often it's not that really the employer insists on having the civil law contract, but the developer says, no, I want to work as a creator. I'm creating things, I'm creating software, and I want to, and I know that this work is being created. I can transfer your rights to me, to you, etc., etc. Most of the personnel perform the same task. So sometimes you will have a case that really people have different forms of engagement or employment, but they do actually the same thing or very similar thing. They develop software for the parent company, which is then offered to clients in the United States. The working conditions, and that's important point. Working conditions of all developers in Poland, regardless of their form of contract, are the same in terms of holiday entitlement, sick leave, and overtime. And the question, which you can guess is rhetorical question, is it acceptable to maintain the structure given that nothing problematic has happened for many years? Because the main argument is always when we approach such companies, when they come to us for advice, they also say, no, why we should change anything if nothing problematic has happened for many years, because this is not, as I mentioned earlier, this gig economy, so short-term contracts, and you have new people. You have normally with this IT company, you have people who work for years for the company, and they've been so the contract for specific work being re-signed once again, is being repeated every year. So the question, as I said once again, is it acceptable to maintain this structure? And the answer from us is of course not. Is of course not.
Yeah, as my colleague said, the state labor inspectorate is vested with broad inspection powers in relation to employers, while it does not have the authority to independently reclassify contracts in cases where violations of law are identified by these inspectors. They may issue some kind of formal recommendations and orders or post-inspection statements, and may also bring court actions to determine that a given contract is an employment contract and not a civil law contract. And the inspection powers are also vested in ZUS, social insurance institution. And their inspections may cover inter alia the registration for social security, as well as the accuracy and reliability of calculating, deducting, and paying social security contributions. So within this scope, ZUS may review, for example, contracts for specific work concluded by a company in order to determine whether in substance such contracts do not in fact have the characteristics of employment contracts. And a contribution payer who incorrectly classified contracts of mandate and thus failed to pay the appropriate social security contributions is exposed to negative consequences, including the obligation to pay the outstanding contributions together with interest.
Yes, so in this case study, we wanted to show you the real example from the market is that basically what should be done, they should review the contracts and decide. Of course, the best solution would be to move everybody to employment agreement, but if that's not possible, to really verify every contract and see whether this can whether it can be defended as a contract for specific work and B2B agreement. But as you can see from this case study, and my thesis would be this, that if you as an employer, if you really give people holidays on a regular basis, so 26 days per year, and if you honor the sick leave, so if they are sick, you pay remuneration anyway, and if you pay overtime, irrespective of what you do, will be doomed. Yes, it will be, if you use holidays, sick leaves, and overtime, it means that these people, even if they agreed to contract for specific work and they want to be independent, they, as a matter of fact, they are employees, and there is a high risk of reclassification. Maybe the one word or just two sentences on B2B agreements with senior people. I mean, it is possible probably to structure B2B agreements in such way that it's not a holiday, but it's just a period of non-provision of services. But they have to be really independent people. So at some level of seniority, it cannot be applied to every developer that is employed under the B2B agreement, because this would be disaster. So basically, the new reality is that the Polish authorities will look in totality at the picture, and when they see holidays, sick leave, or overtime, so any sign of treating these people as employees, there will be temptation really to maybe not to reclassify, because maybe the new law will not be passed at all, but there will be negative consequences if they discover that people are being employed on fictitious civil law contract or fictitious self-employment agreements. Okay, so that's all for our presentation. As I promised, we are running out of time, but we have 5 minutes to answer your questions. We see some questions being asked, which is hello. Now, yes, we can. Now you can see us on a big on a big screen. So I can see the question: is it problematic that the contract for specific work is signed for a long period, say 2 or 3 years? This I would not recommend 2 or 3 years, because as we explained earlier, subordination, regularity, and place of performance are 3 important elements. So it would be better not to have subordination, not to have regularity, and not to perform the work at the company's office. So 2 or 3 years, maybe not regularity, but it's really too long. Legally, I can say this, that generally this is fine, because Polish law does not impose any limitation on the duration of the contract. So and very often you will hear this answer, that legally this is fine. Under the civil law, under general Polish law, there are no limitation on maximum duration of the contract. So civil law contract for 2 or 3 years is fine. But prolonged contracts, the risk classification by courts or by any authorities is much higher, especially because if such a long contract, which is not typical, because typically this specific work contract should be for 1 month for the time which is needed to perform a specific task work. So and this work has to be delivered to the company. So from my practice, the longest period which could be accepted by authorities, as I said, there are no rules on this, but in practice the longest is 1 year, and it has to be properly explained. Yes, that duration, and this very often, and this often happens in IT industry. When you prepare a software, it requires continuous work and testing and doing the new version. So to answer your question, 2-3 years, I think it's much too long. It is formally okay, but for the inspectors this would not be okay. So it should be 6 months or 6 months. I think in practice would be sufficiently long, and then it has to be new contract signed and if there is a continuity and this person is really continue creating a new version or new model of the software, then the new contract. So you have to if you want to engage such person and he wants to work under the specific work contract, the contract has to be signed every 6 months. Let's say the new contract should be signed, and the specific result has to be really delivered and accepted by the company. There are many rules. There's no time now for this to explain this, but it has to be the work has to be created. The contractor has to really show that the work was created. There has to be proof. Very often when we talk about software, there is a program which can be shown, and they can verify. They have experts, and they can verify really existence of such a software. So this is the question about the civil law contract.
And another one is why the amendments to the draft law on the state labor inspectorate competencies were postponed.
Yes.
So Prime Minister, Polish Prime Minister Donald Tusk opposed granting the Państwowa Inspekcja Pracy inspectors power to issue administrative decisions reclassifying civil law contracts, like contracts for specific work or B2B contract, into employment contracts. He viewing it as overly burdensome for businesses, despite prior weakening of retroactivity and immediate enforceability. So this sparked heated debates during the cabinet session, leading to the withdrawal of the project by the government legislation center.
Yes, and we will have 2 minutes for one more question. What is the that's a good question. What is the public support? Very briefly, what is the public support for the proposed changes for the proposal in Poland? So I was checking this morning. So the public support is quite significant. It's 60% of when they do the survey, 60% of population is supporting these measures proposed by the government. But as I said, this is just, I think, beginning, because the draft law was being prepared last year for 6 months, and there have been constantly changes and discussions, and they never really even presented in public the full proposal, but there was just information about the new about the changes which are being adopted. So now we'll have a full discussion about this, and public support is 60%. So more people are voting for workers' protection instead of business flexibility. Nevertheless, the government decided to stop it because employers, unions, and various institutions raised really, I said, it sparked intense controversy. It was really, well, there were so many discussions and debates and controversies that they decided to stop it. So now there will be time to reflect and decide what to do. But it is not that the proposal is unpopular. The other way around, it's very popular, and people. Of course, there's a lot of, I think, misinformation, because people. I don't know how the question was asked, because if you ask a question whether are you for cancelling the junk contract, because they very often refer to this as a umowy śmieciowe. Do you support the combating the junk contracts? Then probably you have 99% acceptance. Yes, we want to get rid of junk contract. But as we try to explain, that this is not really junk contracts. This picture is much more nuanced. Yes, as one more question I think would be good to answer. The question is, what is the so-called entrepreneur test? This is a good question, and I see that you know the subject. So, entrepreneur test is a formula that how authorities can measure whether the contractor is independent. So, if I mentioned this, multiple clients. So they sometimes the authorities apply this entrepreneur test. So they can measure, they can list of contractors who have just one client, and if you have just one client, means that you provide services only to one entity. So it is like an employment relationship. Under employment relationship, there's an employer and employee and close cooperation. So authorities are looking for some simple formulas or simple solutions how to measure who is not independent, who is fully dependent on the company. So they invented a couple of years ago. They invented this entrepreneur test, and they can go by the list and see. So everybody who has just one client who could be on the list of suspects as a potential fictitious self-employment. So to answer your question, so this is the entrepreneur test, but this is very important point, how to minimize the risk of reclassification. To arrange the situation where your contractor has at least two clients. So he's sending the main invoice to the company where for the provision of services, but also he's got possibilities to issue another invoice. Then he's got two invoices, and this means that the entrepreneur test has been passed. Yes. Okay, I think it's we've run out of time. It's 12:12. Thank you very much for your attendance and for your questions and for listening to us. As I said, this is the first of the series of webinars in 2026. We are very happy that the topic was not prepared by us, but by coincidence it happened that this is really one of the hottest topics on the Polish market at the moment. I invite you to listen to the Polish radio, Polish TV stations during the coming days, because there will be more discussions and more explanations. One of the questions Philip was answered about is why it was postponed. Maybe we'll know more when the politicians will talk to the media, because we just have the signal that Prime Minister Donald Tusk disapproved the proposal, and he decided it should be sent to for revision. But of course, there were also rumors that there was really very fierce, maybe not fighting, but discussions within the government, because allegedly everything was approved and it was just a ready product to go to the Polish Parliament for being adopted. So we will. So if you read Polish, if you can listen to Polish radio, TV, you will learn more. If not, we will come up with maybe probably another webinar once we know more about the subject. So for now, thank you very much.
Thank you.
And see you again. Thank you. Bye-bye.